Do's and don'ts in a domestic violence injunction hearing. Do conduct your hearing in a courtroom if possible. If it's required that you conduct your hearing in your chambers, make sure that you have your bailiff present. Make sure that you are ever vigilant, as well as your bailiff, with the body signs of the respondent. Make sure they're properly separated. Ensure that there's no contact between the parties under the table, that the respondent is not using his feet to communicate with the respondent under the table. And make sure it's a very safe environment for the petitioner to be able to communicate. If you're doing your hearing in your courtroom, which we do here, make sure you keep the parties separated. Generally, what happens here is we keep the petitioners in the courtroom, where they're secured with the bailiff, where they get some feeling of familiarity with the courtroom, and the respondent remains outside. This way, the parties are separated. If in your jurisdiction you have the ability to have the parties separated outside of the courtroom but in separate areas, then that is an opportunity that you should take advantage of. The most important thing, though, is make sure the parties are separated. Make sure if the parties bring witnesses with them and family members that they too have a separate area so the petitioner can remain safe in the courthouse. At the conclusion of the hearing, allow the petitioner to leave before the respondent is dismissed. Generally, a 15-minute window is a good amount of time to allow the petitioner to depart from the building and to enter his or her car and leave the property before the respondent exits the courtroom. If you have a sense or some concerns that there may be an additional time that's needed, then make sure that you properly retain the respondent before the petitioner leaves the courtroom. Also, if at the time the petitioner is seeking to vacate or dismiss a petition before a permanent injunction was entered, make sure that they have an opportunity to speak to a domestic violence advocate before that decision is made, and make sure that you note it on your memorandum of disposition. Before each stage of any proceeding, make sure you familiarize yourself with any other litigation that's going on between the parties. They may have civil cases in another division. They may have a divorce pending or paternity action. Make sure if there are cases in other jurisdictions that you properly determine who should have jurisdiction. And it's very important that you familiarize yourself with all other pending litigation. Make sure if you enter a permanent injunction that you address all temporary support issues. And that means temporary child support as well as temporary spousal support. You also may need to address issues of time sharing. As it relates to child support and spousal support, any determinations you make are on a temporary basis. And as to time sharing, you should utilize any supervised visitation centers that you have in the courthouse or third-party agencies that support your court. You can also order, if you believe it's in the child's best interest, unsupervised time sharing. However, it must be through a responsible third party. The court will make a determination as to whether the time sharing should be supervised or unsupervised, and then set up the proper third party to assist in facilitating time sharing. When you're addressing time sharing, always keep in mind what's in the best interest of the minor children. Make sure that your time sharing schedule is very detailed as to drop off and pick up locations. Oftentimes, it's helpful to have a drop off and pick up at the minor children's school or daycare facility. This way you don't have to utilize a third party, and there's no opportunity for the petitioner or the respondent to have contact during the exchange of the minor children. If you elect to use a third party to supervise time sharing, make sure that you've had an opportunity to communicate with that third party in court, and ensure that they are a responsible third party and that you have properly vetted them as much as you can to ensure that they want to supervise the time sharing and that they will be good at doing it. The other thing, if in fact there are minor children involved, you should refer the respondent to a parenting class. And if there's alcohol abuse, you can also refer the respondent to Alcoholics Anonymous, or they'll be evaluated through the Batterers Intervention Program for alcohol abuse and be ordered to seek treatment according to the program. At the time of the final judgment, you are also going to provide the respondent with a notice to appear in 30 to 45 days at a compliance calendar. That compliance calendar will be solely for the purposes of ensuring that the respondent is complying with your order with respect to completing the Batterers Intervention Program or anger management or any evaluations and treatment you may order. It's very important that you advise the respondent of that at the final hearing to ensure they've received proper notice and that they appear at that court date. If they fail to appear, you do need to advise them a warrant will be issued for their arrest, and if they fail to comply with the program, they may be held in contempt. Make sure you have a protocol in place in which you can expeditiously handle any post-judgment and contempt motions. They should be immediately placed on calendar and heard accordingly once you've entered a final judgment. When you're entering a child support order as well as time sharing, it's important to advise the parties that the order that you're entering is a temporary one, and that in fact if they have a divorce pending or are seeking to file for divorce or a paternity action, that judge in the family division would enter a permanent order as it relates to time sharing and child support, and that this is just a temporary order and any relief can be changed in the future. Make every effort to allow the parties separately to view the 11th Judicial Circuit video of the effects of domestic violence on children before each and every hearing. Prior to every hearing, a respondent should always complete a firearms and ammunition affidavit. That affidavit must be sworn to and it must be completed in its entirety. Once the affidavit is completed, it should be provided to the judge and a copy should be provided to the petitioner. If you find that the respondent has not surrendered their firearms or ammunition in compliance with the temporary injunction that was entered against them, you should immediately enter an order which will be served on the respondent at the conclusion of the hearing, ordering them to surrender the firearm as well as the ammunition immediately. You should also utilize court staff to conduct a NCIC search on all respondents to determine if in fact they have a national criminal background, and that should be done before all domestic violence hearings. All OBOs, meaning on behalf of a minor child petitions that are filed under Chapter 741, should be transferred to the Dependency Division so that a dependency action can be initiated in that division. Every court should have a protocol in place whereby if a respondent violates a permanent injunction or even a temporary injunction, there should be a mechanism in place to communicate with the state attorney's office as well as law enforcement. Those opportunities should be available to the petitioner so they can communicate those violations, and so those violations are properly pursued by law enforcement and or the state attorney's office. There are many things that you should never do in a domestic violence injunction hearing. Number one, never enter a mutual domestic violence injunction. The court only has jurisdiction where a petition has been filed by a party. If the respondent is asking for a domestic violence injunction against the petitioner but has not filed a petition, you do not have jurisdiction to enter a mutual injunction. Also, never send the parties to mediation. Ever. Also, never decline to order child support or any sort of spousal support that the petitioner is seeking. That temporary relief is permissible under the statute, and it is also requested in the petition, and that is something that the court must address and must properly adjudicate on a temporary basis if in fact you're entering a permanent injunction. Never award time sharing, child support, or establish a parenting plan for anyone who is not the legal parent. And if a respondent has not legally established paternity and declines to acknowledge paternity at the hearing, you cannot award child support or time sharing. Also, when you determine that a batterer's intervention program should be ordered and pursuant to the statute must be ordered, do not decline to order the batterer's intervention program simply because the respondent has a long work schedule. They're unable to comply with the program because it conflicts with their personal needs in their life. If it is required by statute, you are required to order the batterer's intervention program. Also, please don't confuse the batterer's intervention program for anger management. If the parties have an intimate relationship, the batterer's intervention program always applies. If they do not have an intimate relationship, for example, they are siblings or mother or father, or they don't have a intimate relationship at all, it's a stalking case, for example, repeat violence, then anger management is appropriate if there is no intimate relationship.